Sponta, welcome.
Thank you, Mr. Chair. Members, today I'm pleased to present AB 2498, and this bill does two things. First, it would better protect the identities of human trafficking survivors by adding an exemption to the Public Records Act. Currently, the name and address of a trafficking victim becomes public record unless the victim actively requests from a law enforcement officer that their information remain confidential. This bill will remove that burden from the human trafficking victim by requiring them to opt in instead of opt out of having their identity listed under the State Public Records Act. Second, this proposal would address concerns raised by district attorneys who have spoken with me about the challenge of getting trafficking cases heard in our court system. And it would add the crimes of human trafficking to the list of criminal actions that take precedence over all other criminal actions in the order of trial. That would not be a mandate. It would be an option and allow judges to prioritize human trafficking cases along with other high priority cases like murder, sex crimes against minors, elder abuse, and other critical time sensitive cases. So with that, I think it's a relatively straightforward bill that makes two changes that are important as we continue to address human trafficking as a legislature, as a body. And I have two witnesses here who are willing to testify. Assistant District Attorney from Alameda County, Sharman Bach, as well as Hannah Haley, Policy and Communications Associate from West Coast Children's Clinic.
Thank you. So your first witness, please. We do have a motion from Mr. Alejo and a second. Your first witness, please.
Hi, my name is Hannah Haley. I'm Policy Associate at West Coast Children's Clinic. West Coast is a children's mental health clinic based in Oakland. We serve about 1,700 kids in the Bay Area each year. And one of our programs, the Sea Change program, is an intensive mental health program for commercially sexually exploited children who are frequently the victims of human trafficking. We serve about 120 youth per year through that program. Our clients in that program are frequently part of investigations and trials against their traffickers. I think speaking with our clinicians, they estimate it's about half of their clients are involved at some point in an investigation or a trial. It's really imperative that we keep their information private. I don't think many of them know that they can even request to keep their information private, and it puts them and their families at risk of retaliation, and it further also puts them at risk of targeting by other traffickers who might be looking for vulnerable youth to start to traffic. I would also say that by expediting the trial, we would protect youth from further traumatization. Every time they have to relive the experience of their trafficking or talk about it again, or just even wait for there to be some sort of resolution to the case, it sets them back in their therapeutic process and the process that they're going through to heal. So we would respectfully urge your aye vote on this legislation.
Thank you. Next witness, please.
Good morning, Charmaine Bach.
Could you use the microphone, please?
Good morning, Charmaine Bach, Assistant District Attorney in Alameda County. I have been a DA for 27 years and had the honor to help start our first human trafficking unit back in 2005. I have also been a co-author of Prop 35. I have been in court many times with victims of human trafficking, and I can tell you that there's no harder case to prosecute than a case involving a trafficker. It's the only time, really, in my experience, where there have been threats in the courtroom, where the pimp has all of his people in there, all of the others in the trafficking hierarchy that did not get prosecuted are oftentimes in the audience. They're there when the case is called at calendar. When you get stuck in the hallways with these people, the tension is intense, the threats fly around. I've been threatened. The police officers I've been with have been threatened in the hallways when prosecuting these cases. So it is actually imperative that these cases be on the same track as a child molest case or a rape case or a sodomy case or any of the other cases that get that kind of treatment. Similarly, I think we have an equal protection issue, and it's important to include human trafficking in the list of crimes. When you think of, remember back in school you did those Venn diagrams? Well, when you look at all the other crimes that are listed in that list, many of them are occurring to human trafficking victims, from rape to molest and so forth. So we respectfully request your aye vote and happy to answer any questions.
Thank you. Other witnesses in support?
Thank you, Mr. Chair. Members, Dawn Kepke with McHugh Kepke and Associates on behalf of Crime Victims United of California, also in support.
Thank you.
Danielle Millay with the California Alliance of Child and Family Services, also in support.
Thank you. Anyone else in support? Seeing none, is there any opposition?
Good morning, Mr. Chair and members. Kevin Baker for the American Civil Liberties Union of California. We support and are sympathetic to the author's concerns about protecting these victims. We are also mindful that transparency in government records and proceedings is a fundamental aspect of democracy. So we are appreciative of the direction that the author has taken with the amendments to kind of fine-tune this, and we'd like to work with the author and the committee on a couple outstanding issues just to make sure that we haven't gone further than we need to go.
Thank you. And Mr. Bonta, there were some amendments proposed. Are you taking those as author's amendments?
I am taking those. Thank you. I apologize for not indicating that earlier.
No worries. Anyone else in opposition or concerns? Seeing none, I'll bring it back to the committee. Questions, comments? Seeing none, Mr. Bonta, you may close.
Thank you for your consideration, Mr. Chair and colleagues. This is a bill that has widespread support from law enforcement, victims' rights advocates, and others, and I think it really adds value as we continue to address the issue of human trafficking this year. So thank you for your consideration and respectfully ask for your aye vote.
Thank you. Recommended motion is do pass as amended to privacy and consumer protection. We do have a motion and a second. Call the roll, please.
Stone?
Aye.
Stone, aye. Wagner?
Aye.
Wagner, aye. Alejo? Aye. Alejo, aye. Chow? Chu? Gallagher? Aye. Gallagher, aye. Weber? Holden? Mainshine? Ting.
Needs two more votes. We will put it on call until we get everybody back.
Thank you, colleagues and staff.
Thank you. So next, that brings us to item number 6, AB 2566. Mr. Nazarian.
Good morning, Mr. Chair and members. Under existing law, various documents are required to be validated by public notaries. Common types of notarized documents include wills, deeds, trusts, medical documents, and guardianship letters. Existing law mandates individuals to have a valid form of identification in order to have a document notarized. The lack of acceptable identification serves as a major obstacle for the 2 million undocumented immigrants living in California. Individuals are denied access to essential services, as current law prevents notaries from relying on valid foreign consular identifications and passports. AB 2566 adds valid consular identification cards and a foreign passport to the list of acceptable documents to prove identity. Consular ID cards are now being accepted as a valid form of identification by many U.S. cities, counties, and financial institutions such as Bank of America, Wells Fargo, and Chase, to name a few. According to the Mexican Embassy, it reported that as of August 2013, more than 371 countries, 356 financial institutions, and over 1,000 police departments accepted matricula consular cards as a valid proof of ID. Additionally, this bill is consistent with AB 60 as to the documents accepted to obtain California driver's license. AB 2566 increases accessibility for undocumented immigrants in identifying themselves for purposes of obtaining notarized documents. Notarized documents protect families from litigation and fraud and help families preserve what is lawfully theirs. With that, I'd like to introduce my witness, Joseph Viela, on behalf of the sponsor of this bill, Chirla.
Hi, good morning. My name is Joseph Vigela on behalf of CHIRLA, the Coalition for Humane Migrant Rights of Los Angeles. I'd like to thank the author for authoring this bill, also the staff of your committee for all the help that was provided in regards to this particular issue. The purpose of this bill is very simple, and that's to provide day-to-day important services to all the residents in the state of California. That includes undocumented immigrants. Current law prohibits another public from acknowledging a written document unless he or she can provide proof with sufficient provided with sufficient evidence that that person is making acknowledgement has the right identification. This bill allows a public notary to reasonably rely on valid consular identification and or passport from that individual's country of citizenship. In essence, this particular bill provides the opportunity for undocumented immigrants to have access to these services. These services are important to undocumented immigrants who have deep roots in our state. Research from the University of Southern California indicates that more than half of the undocumented population in our state has resided in the United States for more than 10 years. These services are critical to the undocumented population. As immigrant rights organizations, we educate our membership to ensure that they have a power of attorney and legal guardianship in case they are detained or deported. These documents are critical to make sure that their property is protected, but then most importantly, that they have someone that they trust to take care of their children's other property. And with that, I respectfully request your support for this bill.
Thank you. Any other witnesses in support? Seeing none, is there any opposition? Seeing none, I'll bring it back to the committee. Questions, comments? Mr. Gallagher?
Yeah, I know back in 2003, the FBI did identify that matricular consulars, one of the problems with them is that they, because of how they're issued, there's not always the ability to really verify that that is the person that it purports to be. And that's one of the big issues for a notary is when they're acknowledging something, they're having to verify that this is the person that they say they are. So has there been any, since 2003, has there been any changes that have helped make those more secure so that we can verify identity?
Yeah. Sure. So yes, the answer to that is yes. There's two big changes that occurred in regards to that particular issue. One in 2005, in which there was a central database, that pretty much puts all those individuals that are requesting those IDs into one database. But then most importantly, recently, due to AB 60 and different changes that were happening across the nation, especially the Mexico Council have at least 12 forms of changes that they did to their matricula in which it was enhanced security, and that is that it cannot be duplicated. And I'll be happy to send those changes to your offices. They're in details such as holograms that are hitting, as well as the databases, which is more important. And as the author indicated, as Senator Nasseri indicated, these particular documents are accepted by private entities as well as local governments, as well as, in this case, the state of California in regards to the Department of Motor Vehicles, but then most importantly also to the federal government when someone is also trying to identify themselves, they can provide that as a form of ID in addition to other types of options that they have.
Just quick follow-up. What would be the impediment from, going to and getting, like, say, a California driver's license and then using that as your ID? Is there something that's preventing that from happening?
In the reason that we decided to move this particular legislation forward is that we acknowledge that not all individuals who are undocumented will be able to apply or actually will willingly apply for a driver's license. One, they may not want to drive. And two, there's also what we acknowledge is that there are individuals that do not have the means to actually buy a car and then get a driver's license. And so this allows individuals who do not have a valid driver license under AB 60 to also have access to this particular service. And California is moving towards integrating undocumented immigrants as well as those who are legal. And this is a step forward as it relates to ensuring that they have access to all the services, regardless whether they have an AB 60 driver license.
Mr. Alejo.
Mr. Chair, I'm going to be supportive of this bill today, but I did want to express some concerns. That's our duty here in the Judiciary Committee with this bill, and certainly as the author of AB 60, there was always a balancing act, and certainly Chirla was a big part of getting that legislation enacted, and but there was a lot of balancing of interest and working with law enforcement, dealing with some of the identity issues, security issues, and for this bill to get serious consideration, I think for the administration, I think these questions have to be answered as the bill moves forward. Because even when the DMV accepted certain documents, for example, the matricula, they didn't accept every single one outright. They have a list of consular ID cards that they've worked with those consulates to add additional security features. So there's a list of actually what countries they've accepted. They've expanded that in the second year, but it forced consulates to put greater security measures in their matricula cards to address those kind of security and identity concerns. So as we're moving this, it's not any matricula card, and even the DMV, when it comes to some of these, they accept current matriculas, and this would allow them consular ID to be able to utilize expired consular ID cards. These are just some of the concerns I'm raising because I think they have to be addressed as the bill moves forward, and certainly if you're trying to put it in a signable form for the administration to consider, I think they have to be addressed before then. But I know what the goal is, and the goal is to provide greater access to people who sometimes struggle with some of these documents, but there is a balancing act that has to be addressed as well.
Thank you. And Mr. Zarin, there are some proposed amendments here that I believe we've worked some amendments in the bill.
I'm certain I have. I didn't have it in my notes, but yeah. We have, yes.
Just be clear. Thank you. Because the recommended motion is do pass as amended. No further questions. Mr. Nazarian, you may close.
I respectfully ask for I vote. Thank you.
Thank you. I still need a motion. So we have a motion. Okay. Mr. Alejo and a second by Mr. Wagner. Call the roll, please.
Stone?
Aye.
Stone, aye. Wagner? Aye. Wagner, aye. Alejo? Alejo, aye. Chow? Chu? Gallagher? Weber?
Use your mic.
Gallagher, aye. Weber, Holden, Mainshine, Ting.
Still needs 2 votes, so we'll put it on call.
Thank you.
Thank you.
Thanks.
Next author looks like we have is Mr. Lowe, item number 1, AB 1887. This bill we heard last week, so I'd like to limit discussion on the amendments. So if you could present on the amendments and let's sort of focus there, then we will finish our conversation.
Very good. Thank you very much, Mr. Chair. And yes, since the last hearing, we've amended the bill to be prospective. Any state that enacts discriminatory anti-LGBTQ laws after June 2006, 2015, the date that the Supreme Court ruled in favor of marriage equality, then state workers would be prohibited to traveling to that state. Secondly, the bill was further amended to identify the Attorney General's office to publish and maintain a list of states to which provisions this bill would apply to. Today, only the state of North Carolina would be a state that would be prohibited as such. And just as a note, the governors of Washington, Vermont, New York, and the mayors of San Francisco, Seattle, New York, and Boston have also passed such similar laws. And so with me here today are Joe Michael from Equality, California, and Amy Whalen for the National Center of Lesbian Rights.
Thank you. So your first witness, please.
Good morning, Mr. Chairman and members. My name is Amy Whalen. I am a senior staff attorney at the National Center for Lesbian Rights, and we are a co-sponsor of AB 1887. We were counsel for the Tennessee plaintiffs in the consolidated cases that went before the Supreme Court in the Obergefell decision. And at that time, we anticipated that there would be backlash similar to what we're seeing across the country in relation to the Supreme Court's decision. As states like North Carolina and Mississippi seek to target and jeopardize the lives of their LGBT citizens, others have just as forcefully opposed those efforts. The federal government
and again, I'm sorry, we've had debate on sort of the underlying need and desire for the bill. What we're really looking at are the amendments today.
Yeah, and sorry, I'll be brief. We're just urging that California is a national leader on these issues and has the largest economy in this country, and we're urging that the state join the chorus of voices in opposition to these bills in order to come out and ban travel to states that pass these measures.
Thank you. Next witness, please.
Mr. Chair and members, Joe Michael for Equality California. We are proud to co-sponsor this and work on the bill with Assemblymember Lowe, and we really appreciate the committee's work on this bill to make sure that it will achieve its intent. It's definitely a difficult thing to target, so we greatly appreciate the efforts that were undertaken here, and we think that the amendments will align the bill with its intent and with the national effort to address this backlash, which is basically the most virulent anti-LGBT campaign that we've seen, at least that we know of up to this point. So we very much appreciate that and respectfully urge your support today. Thank you.
Thank you. Anyone else in support?
Becca Kramer, ACLU of California. We're also in support.
Thank you. Anyone else? Is there any opposition? Seeing none, I'll bring it back to the committee. And thank you, Mr. Lowe, for working with us on the amendments. I think it goes a long way to addressing some of the issues that were brought up last week in this committee, and having an objective standard, asking the Attorney General to do the vetting, I think answers a number of the questions. Any other questions or comments from committee members? Mr. Gallagher.
Thank you, Mr. Chairman. Assemblyman Lowe, I guess my concern with your bill is, I think we all agree that we don't want to allow discrimination against people. We also, I think, all agree that we want to protect religious liberty and freedom of association. And I think we're seeing that there are gray areas out there where we're having to reconcile those two values. And some states are maybe going to draw the line differently than others within that gray area in ways that we may agree or disagree. But I think to sort of punish a whole state and the businesses and people that are in commerce there who may actually agree with your position, and we're kind of punishing them as well by saying we're going to ban state travel to those locations. I mean, I know just not that long ago, SAC Metro Chamber did a trip to Indianapolis where they were trying to learn, some of the things they'd done there that had nothing to do with, what we're discussing, but had, they were learning how that city had dealt with different economic development and other issues. And I think, this kind of hardline stance against an entire state, I guess with the amendment, it's just North Carolina, but still there may be things that we could learn from, North Carolina legislators, cities, towns that, there may be a reason for us to do state travel there. To just put a hardline ban, to me seems maybe just a little bit overboard. So that's, I can't get there on this, and those are just some of my concerns. And I don't know if maybe you might be able to address some of those.
You're welcome to, or you can address those in your close.
Right.
I can address them close.
Okay. Mr. Mainshine.
Mr. Lowe, thank you for bringing this bill. I do have a few questions, and I want to talk a little bit about how it would actually work. So I'm not talking necessarily about the substance of it, but more just the practicality of it. For one, it's being housed with the Attorney General to make that determination. And on other issues before the Attorney General, we've been advised there's staffing concerns. They don't have enough staffing to do certain functions, and I think the legislature, in fact, increased their staffing to do those functions. How would this affect their workload?
I'm not sure, but I have not consulted with the AG's office specifically on this. But in terms of the implementation, we, since last hearing, we identified the Attorney General's office as the appropriate entity to do so.
Okay. Do you plan on consulting with their office on how they would
Yes,
staff
they've been consulted, but they're not here today to speak to the...
I think that would be important going forward. I also think I'm not sure from a legal standpoint how this definition would work. In other words, reasonable-minded people may disagree on what is, quote, what is a discriminatory law. Somebody may feel, something is discriminatory against a worker. Something may be discriminatory against a business owner, because it's, in essence, a policy decision. Somebody may fall on what is considered to be, quote, pro-worker, for lack of a better term, or pro small business owner. They may be going the same place. They just have a difference as to how you create jobs or how you. And so, how is that determined? Do they have to go through every single law that is passed by the other 49 states and say they have one law that is, in their mind, discriminatory and then ban travel? How does that work as a practical matter?
The Attorney General's office would to administer such intent, and if you read the language, it just very much specifically focuses on gender expression and sexual orientation. And so I appreciate the conversation around how the interpretation might be with relation to some of any other issues, but it's very specifically is narrowed in its approach about being prospective to a particular date and identifying laws that discriminate based on sexual orientation and gender expression as just some of these other issues. Part of the other conversation, I think some have said in part of the discussion, is such that should this not be appropriate for the governor to do in terms of the executive order, or perhaps why not be tailor the bill specifically to the state of North Carolina? Yeah. It's my understanding that we constitutionally are not able to, within the legislature, identify and single out a particular state. So that's why we have not focused on just a specific state like North Carolina, whereas the governor is able to do so with the executive order.
Okay, and that you anticipate my next question, which is, so explain that a little further. We as a legislature aren't allowed to single out a state, because it seems that would be simpler. You could just say, sure, we don't agree with what North Carolina is doing or whatever fill in blank state, and vote on that. So could you explain that? I hadn't heard that before.
Sure. I have from committee staff, if I might, it might not even be constitutional for the legislature to single out states by name. Constitutional Section 16, an executive order also has the advantage that it can be immediately rescinded once the state has changed its laws, so a little bit more flexibility with an executive order. And so this was given to me and communicated as we worked with committee staff here.
And one of the reasons that came up in the conversation a week ago was that this notion of religious freedom, the RFRA laws that are in different states have different impact. So we are asking the AG to take a look at those states that are enacting either directly discriminatory policies or policies that have the effect of actually discriminating. We wanted to make sure that there was an objective body, the AG, looking at that question before making the decision. So this bill is setting a standard and asking the AG to look through that standard in order to make a determination.
Okay. Well, I would say this, Mr. Lowe. I am supportive of the concept, and so I am going to support it today. I do have some. I'm not still totally clear on how this actually works, kind of in day-to-day real life. So I am going to support it today. I would like to continue the discussion as this, assuming it moves forward, as this comes to the floor.
Thank you very much.
Thank you. Seeing no other questions or comments, Mr. Lowe, you may close.
Thank you very much. And I just want to call your attention again to item line 3, in which religious freedom is a cornerstone of law and public policy in the United States, and the legislature strongly supports and affirms this important freedom. And so with that, I respectfully ask for your aye vote.
Thank you. I'm looking for a motion. The motion is due pass as amended, as the author is agreeing to take the amendments that we had talked about, and that they are the subject today. So a motion by Mr. Alejo. Is there a second? I will second that. If you would call the roll, please.
Stone?
Aye.
Stone, aye. Wagner? Wagner, no. Alejo? Alejo, aye. Chow? Chu? Gallagher? No. Gallagher, no. Weber? Holden? Mainshine? Mainshine, aye. Ting.
Needs 3 more votes. That bill is on call. Thank you. That brings us to item number 8, AB 2759. Mr. Levine.